Welcome to In Court, the podcast where we delve into the trials and tribulations of the courtroom. My name is Nina Tornqvist and I'm a criminologist at Uppsala University, Sweden. My research centers on the worlds of the legal professionals with a particular focus on emotion and legal decision-making. I have observed criminal court cases in Sweden for almost a decade.
My name is Chloe Squires and I am a PhD researcher at the University of St Andrews in Scotland. My work looks at the sentencing of individuals charged with terrorism offences, and I'm observing court proceedings in England and Wales.
My name is Nicole Bögelein. I'm a sociologist and criminologist at the University of Cologne in Germany. My work focuses on institutional racism in court and terrorism cases. For several months, I have observed court hearings on low-level offences in German district courts. In this podcast, we dive into complexities we have identified throughout our times observing legal proceedings to demystify what happens in the courtroom.
Nina, you wanted this podcast to be about emotions. Can you tell us how you became interested in studying emotions in court?
Actually, I got interested in emotions of legal professionals because there was surprisingly to me, so much of them. So in my PhD thesis, I did interviews with prosecutors specialized in intimate partner violence, sexual violence, and child abuse. And although they work with crimes that are considered particularly emotional in society, I thought that these prosecutors would be very reluctant to talk about emotions and very much stay with the narrative of the rational, dispassionate bureaucrat. But instead, they talked a lot about emotions. They talked about their own emotions, they talked about emotions of crime victims and suspects, but also about emotions relating to other legal professionals that they meet in their everyday work, like police officers, judges, and defense lawyers. And they talked about how they handle these different emotions. So what really captured my interest was this tension in their work between handling criminal matters with really strong emotional connotations on one hand and a strong objective to be objective on the other hand.
Is there a specific scene from your research that you remember or still have in mind that made you think in particular about emotions?
Yeah, in particular, I remember one of the prosecutors I interviewed. So when I asked her what she believed was the most important ability as a prosecutor, she answered something like, "So I don't think you should put too much, take it home, go and think, poor child." So children are treated terribly badly sometimes, and women too for that matter. Especially the sexual offenses against children are quite unpleasant. And then she added, "You can say that, right?" And I believe this quote really seizes the tension around emotions in legal professionals' work. So this quote also touches upon today's topic, sympathy, illustrating how it is a very pervasive emotion in legal work, yet it is an emotion that needs to be excused. That is something I think is really fascinating. So in most other social spheres, sympathy would be an emotion that we expect when someone talk about victimhood, particularly these vulnerable victims. But from a perspective of a prosecutor, this is something that needs to be really handled with care to be perceived as professional.
I think that's so interesting, Nina. And for me, I think sympathy is a really interesting emotion. But what other emotions do you see play out, and why do you think sympathy is the most important one?
Yeah, so I believe that the courtroom is a very emotionally laden space, and I would say that all emotions can be accommodated in this rich social sphere. And that is why I believe it's so important that we research emotions in the courtroom. So at the center of a court proceeding, there are usually some kind of personal tragedies. From the perspective of lay people, anger, sadness, disgust, shame, regret and remorse, but also hope and content are perhaps emotions that come first into people's mind when thinking about courtroom emotions. So given the stakes involved, one might also want to add anxiety, worry, nervousness. So while there are research showing that there are emotion rules for defendants and crime victims, rules for how we are expected to feel and express feelings in the courtroom, these emotions rules also are important for how people can be perceived as credible and easy to handle in a way for the legal professionals.
So you were just talking about remorse and different feelings like hope that I would actually see more on the side of lay people in the courtroom, like victims and offenders. But you focus mainly on the emotions of professionals, although they are just one group in the courtroom. If I give it a quick thought, I imagine that actually the lay people might have much stronger feelings than the professionals because professionals are not personally involved. It's not about their freedom or about them experiencing an offense. So, how come you are interested in the emotions of the professionals in the room?
Yes, indeed. I do see a lot of different emotions that play out in the court. And I would not say that any of them are more important than any other. Rather, I think all of them need our close scrutiny. Yeah, so I'm interested in the emotions of the legal professionals just because they're supposed to have no emotion. They're supposed to be cool, rational, very dispassionate bureaucrats, and they should be unaffected of the reality that they deal with. So I think this is why it's so interesting to see how they perform this professional role. And I also want to emphasize that this image stems from a fundamental ideological division between rationality and emotion, where emotion are associated with impulsiveness, unpredictability, and biased decisions. So the judicial ideals of objectivity and impartiality do impose a very strong imperative to leave emotions out. But then from my perspective, it is impossible even to leave emotions out, and to act in a dispassionate way do require a very advanced emotion work. And also, I think it's important to stress that both dispassion and ease are also emotional stances. So behaviors that we often associate with judges, prosecutors, and defense lawyers, like solemnity, poise, and confidence, they also do have an emotional flair to them. So although we might perceive that the suspects and crime victims have stronger emotions, there's a lot of emotion work from the legal professionals to be perceived as objective and non-emotional.
Nina, are there any current projects you're working on that deal with emotions? I imagine that for some of our listeners, they might want to follow up on some of these things.
Yeah, so in my latest research project called Just Emotion, led by Professor Stina Bergman-Blixt, we looked into epistemic emotions, and that's emotion that drive knowledge-seeking processes like surprise, curiosity, disinterest, doubt, and certainty. We wanted to look into these emotions to understand legal decision-making processes better.
So, your initial thought for this episode was that you wanted to talk about sympathy. First, the idea was emotions, then you said, let's focus on sympathy. And when I thought about the word sympathy, I immediately had to think of the term empathy as well. And I wondered, isn't that actually the same thing? Nina, can you help me? What are the differences between sympathy and empathy?
So that is a good question. And in everyday talk, we usually use sympathy and empathy interchangeably. However, in the legal setting, it is important to distinguish between them. And that is why I got so curious to understand sympathy and empathy better. So the short answer is that sympathy and empathy are not the same thing. So in the literature, sympathy is considered an emotion that directs one's attention to someone else's suffering and invites emotions to mitigate the other person's distress. So care and concern are central elements for sympathy. For legal professionals, sympathy involves both a threat and a promise in that a certain amount of care and concern for another person's well-being can propel them into engagement and empathic listening, while too much sympathy risks to become biased and simplistic in one's assessment of the criminal case. So empathy is usually not considered an emotion, but it's rather an ability for emotional attunement based on understanding someone else's perspective and situation. And empathy also involves an imaginative process of understanding what other person feels in a certain situation.
So how do you see then this distinction between empathy and sympathy play out in the trials that you observe?
So in the interviews that I have made with judges and prosecutors, they often emphasize that empathy is a necessary skill for them. They need empathy to be able to examine and cross-examine people in court, as empathy helps them to attune with the other person's emotional state. So, for example, understanding what a crime victim feels in the court situation, like, is the crime victim nervous? Then they need this empathic imagination in order to understand what the crime victim feels. And that can actually help legal professionals to ask the right questions so that they can calm down the crime victim, or perhaps ask the court for taking a short break. Empathy is also perceived as an asset for legal professionals when they are assessing a criminal event, evidence, or intent. So these findings also rhymes with previous research that demonstrates that empathy enhances objectivity and professionalism among legal actors. So while there is a consistency in the literature on the usefulness of empathy in the courtroom, the professional practices of sympathy is much more controversial and disputed. So in short, both socio-legal scholars and legal professionals point out that in order to perform objectivity, it is important not to feel sympathy and compassion, since these emotions are so intrinsically linked with threatening impartiality and being biased. And that's, of course, why I wanted to go there and understand sympathy more in depth.
You already mentioned the words neutrality and objectivity. That is, actually, legal professionals are supposed to be neutral and objective. So how do you see these emotions that actually oppose that state of mind? How do they play out in the courtroom?
Yeah, so to repeat myself a little bit, so in the legal setting, which is a setting that really imposes strong emotion rules for the legal professionals to be unemotional, still different emotions have different status or valence in the courtroom. So some of them are more appropriate and some of them are less appropriate. So in short, empathy is an emotional aspect of legal work that passes in the legal setting, while sympathy is shunned and met with suspicion. But still, from my experience observing court proceedings, I think that the courtroom is a space that is really saturated with sympathy. And I would love to hear what your thoughts is on this, Nicole and Chloe, from your experience observing other kinds of trials that I have been doing. And also I think that some researchers, Kuchenbach and Losecke, they talk about court trials as sympathy contests. And really what you could see that the judges do is kind of giving sympathy to the different parties in a court trial.
Well, to not really answer your question, but to give an example from the cases I have observed, what I often saw is how judges, mainly, they try to fight their feelings. And when you can see how they feel something is unjust in the outcome when they say, well, from a legal perspective, this is right. And then you can almost hear them not saying, but in my personal view, So I felt that this is very much a place to hide behind, to say, well, the legal perspective requires, the legal perspective does. But at least in the cases I observed, they try to keep a pan face and try to be quite unempathetic, actually, in the courtrooms. Only after giving their verdict and ending the case, they might add one or two sentences and be a bit more open and say, well, I wish you the best and I hope things so show this more human side. But I found that during the proceeding itself, they try to be very, as you said, professional and try to keep up their objectivity, which you can see how they fight it at the same time. How about you, Chloe?
Yeah, I think in my experience, it kind of echoes what you've just said, Nicole, actually, that judges kind of hide behind what the legal perspective is. But I think in the UK context, because we use a jury in trials, it kind of makes things a lot more complex, actually, because the judge almost has a level removed from the case because the jury has to make their decision on what they think in terms of guilt or not. So it would be interesting to see the degree that plays potentially in jury considerations, sympathy and empathy. What does the jury think? But yeah, I think in the UK we have a slightly different system, so it's potentially more difficult to kind of mediate where those emotions play out, really.
So back to the topic of sympathy and the research you've done, Nina. You wrote a paper on sympathy, and in this paper you used Neil Christie's example of the ideal victim. The ideal victim is actually characterized by 5 points. It is weak, involved in a respectable activity. At the time of the offense, it is in a legitimate place, and the perpetrator is an unknown person to the victim. And also he or she is superior to the victim in some sense. You then came up with the term sympathy broker. Can you explain the connection and expand a little on that?
So, writing this article, I was inspired by a scholar named Candace Clark, and she has written a very classical work on sympathy. And she uses banking analogy to deepen our understanding on how sympathy play out in social relations. And very brief, Clark says that we all have a sympathy margin that we build over time, and that sympathy margin is related to our social status and interactional pattern. In a reciprocal relation, we give and receive sympathy on more or less equal terms, and we also need to use our sympathy margins or credits responsible. Otherwise, we will not earn this sympathy margin. So, however, at times we might suffer from many plights at once, and other people might think that we are overdrawing our sympathy margins, being drama queens or crybabies. And in my analysis of the courtroom interaction, I looked for sympathy cues. Sympathy cues is really a concept where I expand on Clark's idea of cues as invitations for specific emotions. So in the legal context, a sympathy cue refers to information about the crime victim or about their relationship to the defendant that strengthen their victim status. So a sympathy cue then emphasizes the vulnerability or the victim's irreproachability, or highlights the power imbalance between the victim and the perpetrator. And my idea is that prosecutors and victim counsels, they use sympathy cues for their clients, the crime victim, while the defense lawyers, of course, use sympathy cues for the defendant, trying to increase their sympathy margin that is evaluated in the court. So, in line with Clark, I argue that prosecutors, victims' counsel, and defense lawyers can be seen as a sympathy broker when they are making claims for their clients to either call attention to someone else's plight and thereby function as an intermediary between the potential recipients of sympathy and the sympathizers. So, for example, emphasizing their client's troubled past or good intentions, Clark pointed out how defense lawyers are acting as sympathy brokers and actually might influence the sentencing decision. But in my article, I also wanted to highlight how Christie's concept of ideal victim is important for prosecutors and victim counsels to highlight the victim status and the sympathy margin of the crime victim.
I think the notion of sympathy brokers is a really interesting one, and I think it's a really interesting theoretical discussion to have. Have you got any example for people who haven't done this kind of research or might not be familiar with the theoretical background? So what kind of everyday example could you maybe give?
Yeah, so I think sympathy is an interesting emotion because it's also strongly entangled with power mechanism, and sometimes it is considered a moral emotion. So it really highlights sympathy's capacity to create and maintain social boundaries and hierarchies. So a telling example of how sympathy is entwined with social status is when we receive sympathy in situations where we do not expect it. And particularly if we get sympathy from a person that we believe have a lower status than we do ourselves. Let's say we have a lecture and afterwards, we feel a little bit disappointed with our performance and a little bit like we have failed in this lecture. If someone, like a student, comes up and say, "But oh, you really did your best. I could really see that you were trying up there," then their sympathy might not be what we expected and not what we wanted, because it really, really emphasizes this failure instead of helping us overcome it. So sympathy can also be used as a power device to put someone in place and to make someone really feel belittled. But trying to make a more strong connection with Niels Chris's concept and Clark's work. I think that Niels Chris's concept with ideal victims is a really great concept, but I also thought that we could add an emotional aspect to this concept and really enrich it. So like you said, Nicole, I think the concept of ideal victim stresses the ways in which the victimization is unfair and unjustified, and how the victim is not to blame for the criminal incident. So relating the concept of ideal victims to Clark's discussion on sympathy, I would argue that the more ideal a victim is considered to be, the greater sympathy margin they will be granted by society and, by extension, the legal actors in the courtroom.
Nina, you already mentioned the term power being relevant for sympathy. Do you see any other factors it's intertwined with, such as age, race, gender, or anything else?
That is something that I think I, or maybe some other researcher, really need to look into more. So I cannot emphasize enough that I do think that the wider social power structures do play a fundamental role in the way that sympathy is distributed in society at large, but also in the courtroom. And I really would like to analyze how sympathy cues are used by the legal professionals in relation to the different social status of the client. So, for example, how can you emphasize the victim's vulnerability by mentioning factors of age or race or gender? And I believe the best way forward for understanding these dynamics would be an intersectional approach where you kind of combine all of these factors, not understanding them as isolated structures. But I guess also this question really taps into your fields of expertise. So what would you say about age, race, or gender, drawing on your research without having analyzed sympathy in particular?
The question is, where do we see if that sympathy is influenced by one of the concepts we just mentioned?
Yeah, and I think also so in court, the prosecutors and defense lawyers, they would emphasize different dimensions or aspects from their client, trying to evoke sympathy from the judges or the jury.
Yeah, I think that's an interesting suggestion because in my research I look at the way that male and female terrorism defendants are sentenced, but also how they're represented in court. And I don't have a definitive answer for this question, but I think something that surprised me is that male and female defendants actually have quite similar defences actually about vulnerabilities and mental health. For example, one of the big ones that I've noticed, motherhood, is a really big defence for a lot of female defendants. But I think again it comes down to the question of actually to what degree are those narratives accepted or rejected by the different legal actors. And I don't have an answer for that right now, and I think that is something that really does need some further research, but I wonder if there's a propensity to accept different narratives and reject different narratives based on these different factors, whereas maybe the narratives advanced in trials are maybe less gendered and less aged and raced as we initially kind of expect them to be. Nicole, do you see similar things?
From my research on racism in the courtroom, I completely agree. I think how close is the defendant or any person who's speaking in the room to the person who's actually dealing with their sympathy or empathy. We know from social psychology research that we feel more empathy and sympathy with people who are closer to us, who look like us, who we can relate to because we have similar histories. And actually, this might not be true, but somehow we feel that we are more capable of understanding how they feel because they are closer to us. And so what we see when we look at racism in the courtroom is that actually people who have suffered difficult life stories. So if you were forced to migrate from one country to another and you have made really traumatic experience on that route, you do not get the same credits in the courtroom for that as you. I'm sorry, that's a difficult word, but you know what I mean, as someone who is closer to those who actually give the verdict or represent the criminal justice system. We know from research that with people who are racialized, addiction or mental health issues are not taken into account as a mitigating factor, while they more easily are for people who are not racialized and more perceived as people who belong or who are part of the national system. Yeah, so I think all that somehow plays out in this complex of sympathy.
Yeah, and I think it also touches upon an issue that is discussed in the literature on empathy. Like you said, Nicole, the closer you feel to another person, then you would more easily try to take their perspective and also more easily do that, understanding what their situation is. But then I think that is when sympathy can actually be a positive factor within the legal assessment, because sympathy kind of drives, by emphasizing concern and care for another person, you might actually kind of walk the extra mile to understand their position, like to get another empathy instead of an empathy that is close just to stay within your own framework or your own experiences.
So, Nina, we've talked about a lot of different emotions. How do you identify sympathy in the courtroom? How do you kind of see it in operation? How do you know that that's what you see?
This is actually, I guess, the most common question that I get. So how do you study emotions? And I think for this article, I looked at the sympathy cues. So that would be spoken markers inviting for sympathy. So in our research project, we mainly use 3 different kind of methods: classical court observations, but also shadowing, where we follow and chat with the legal professionals in coffee breaks and when they walk to and from the courthouse, for example. And additionally, we also do interviews at several locations during the trial. So in this way, we can compare our observation notes with the legal professional's spontaneous reaction close to the events. For example, if the victim breaks down, we would get how they interpret the situation and what they did to calm down the victim, for example. But we also get their more reflected and considered reflections in the interviews. And I would not say that this choice of methods give us all answers about the emotional life of the legal professionals, but it surely gives us plenty of rich data on the role of emotions in the courtroom. And I'm really interested in understanding what emotions do in social interactions. So it's not so much about understanding the genuine emotions or authentic emotions, because I think that is really difficult and also a little bit complicated on an ontological level. But when it comes to studying particularly sympathy, I believe there are some physical sympathy markers, like friendly smiles, usually interesting with closed mouths, leaning heads, turning to the other person, patting them on their shoulder, or also speaking in this soft, low-pitched voice. And sometimes you can see or hear that the legal professionals do get moved as they do the examination or cross-examinations. For example, they can get tears in their eyes or their voice would falter. And these bodily gestures, I think there are signs of sympathy, but that does not necessarily mean that they have really felt these emotions. So here, the 3 different methods, both with shadowing and interviews, are key to get more elaborated reflections on their emotional experience.
Thanks so much, Nina. I think we've talked extensively about sympathy today. So is there one specific take that you would like to highlight from your research on sympathy?
I do understand, and I think that sympathy is an emotion that legal professionals need to handle with care in the courtroom, because it is linked with bias and perhaps rash decisions. But I also think that sympathy plays a really important role, as it can actually make legal professionals devoted in understanding another person's situation. And I also think my research did show that, just like empathy, it is possible to balance sympathy between the different parties in a criminal court case. And secondly, and perhaps most importantly, I think that sympathy has a very central role for the legal professionals, as it is an emotion that links them with humbleness and humanity. And I think without emotions like sympathy, there is a risk that they would feel or even become cynical and callous. And that is something that many legal professionals that I have talked with really fear, that they would get out of touch with the tragedies that they do deal with on an everyday basis.
Thank you so much, Nina, for this discussion. I think it's been a really interesting one. So that's it for today's episode. Thank you for listening. Speak to you soon.
Bis zum nächsten Mal.
Vi hörs!